In this video, I will discuss the liability regime of notarial auctions under German law, and what decision makers need to understand when enforcing and realizing pledged corporate shares and intellectual property rights. Today, I will discuss an important topic: the public auction of company shares and rights of all kinds. When enforcing against pledged company shares and other rights, it is not the form that is decisive, but the effect. Anyone who treats the public announcement as a mere box-ticking exercise, a minimal notice in the Federal Gazette, risks avoidance, unwinding, and substantial liability exposure in the event of a dispute, especially with unlisted shares, where the auction itself effectively creates the market in the first place. In addition, there is an inherent structural tension. The secured creditor, pledgee, should not, as a rule, control the announcement himself, because he is entitled to bid and may therefore be exposed to allegations of bias and value-destructive conduct, waste/undervalue. In an insolvency context, these issues become particularly acute. This video explains step-by-step why this is the case, what publicity standards Section 1237 BGB actually requires, and why online live auctions are often the decisive lever for proceeds optimization today. Legal classification and responsibility. Rights within the meaning of Section 383 BGB may be realized as a matter of statutory design by auctioneers, bailiffs, or, where the auction is coupled with notarization, by notaries who are publicly appointed and sworn for this field. In enforcement practice, bailiffs regularly decline to conduct such realizations. This is largely because the realization of company shares or other rights typically requires expert valuations, economic and legal due diligence, and a robust contractual framework. Bailiffs generally lack the structural and personnel resources to deliver this. Moreover, pursuant to Section 191(1) GVGA, bailiffs are entitled to refuse an assignment without stating reasons. See also OLG Cologne, decision of 30 December 1999. Ref. 7 VA 299. If shares in a company or other rights have been attached on the basis of a judgment, the enforcement court may, at the request of the creditor or the debtor, order the sale by a publicly appointed and sworn auctioneer pursuant to Section 825 ZPO. Other method of realization. Section 825(2) ZPO expressly provides: the enforcement court may order the auctioning of an attached item by a person other than the bailiff at the request of the creditor or the debtor. New legal framework as of January 1, 2025. With effect of this date, the amendment to Section 383 BGB entered into force. The legislator has expressly emphasized the importance of pledges over rights, and also, for the first time expressly anchored in statute, the conduct of online auctions by publicly appointed sworn auctioneers. The publicly appointed sworn auctioneer is now expressly listed first in the statutory provision as the central authority for the realization of objects and rights arising from contractual and statutory pledges over rights. Their involvement serves to ensure an independent, legally compliant, and fair execution of the realization process, and is accepted by both creditors and debtors. When enforcing claims against pledged rights and assets, the generally publicly appointed, sworn auctioneer specializing in such realizations pursuant to Section 1237 BGB stands for the best possible realization of proceeds. Lack of implementation regulations and practical risks. There are no specific statutory implementing rules governing the conduct of public auctions of rights, neither for publicly appointed auctioneers nor for notaries. However, this traditional field of law is by no means unregulated. A review of the relevant commentary literature quickly demonstrates that non-specialists are exposed to significant contestation and liability risk. Incorrect advice or insufficient expertise can cause material economic loss. Due to many years of practical experience in the public auction of pledged company shares and rights of all kinds, Deutsche Pfandverwertung has in-depth expertise that goes far beyond a purely theoretical approach. The complexity of the subject requires a comprehensive review of all procedural steps. The public auction is divided into three clearly distinguishable phases: generation of prospective buyers, inspection phase, auction process. Generation of prospective buyers, public announcement. The normative starting point. Pursuant to Section 1237 Sentence 1 BGB, the pledge auction must be made public. This publicity obligation is not a formality for its own sake. It is a central legal safeguard. An auction that is not publicized, or not publicized adequately, is unlawful. A bid cannot be validly accepted. The legislator deliberately employs an open-textured legal term in Section 1237 BGB. Its content must be determined exclusively by interpretation. The interpretation of the term to be made public results in three cumulative requirements: personnel range, time appropriateness, qualitatively appropriate scope of the announcement. A. Grammatical interpretation. Public means generally accessible. An announcement is public if anyone can potentially become aware of it. This does not require that every person is actually reached. The decisive factor is accessibility for potential buyers. B. Systematic interpretation. The requirements are met once a substantial proportion of the realistically reachable potential bidders has been given the opportunity to take note of the announcement. This systematic interpretation follows the principle of coherence of the legal order. C. Historical and teleological interpretation. The historical legislator sought the broadest possible dissemination of information to prevent manipulation. The teleological interpretation confirms that the purpose of the provision is to concentrate demand in order to achieve optimal auction proceeds. See BVR Fee 34, 238, 288F. Based on the ordinary meaning of the word, public denotes general accessibility in the technical legal sense. Accordingly, an announcement is public if anyone potentially has the opportunity to become aware of it. This entails an obligation to announce the auction in a manner that enables an undefined group of persons to potentially take note of the auction event. It is not required that anyone actually does so. At the same time, it must be taken into account that it is neither appropriate nor intended by the legislator to make auction announcements accessible to circles of persons who are excluded from the outset as potential buyers, as it were. The grammatical interpretation must then be corroborated systematically. From a systematic perspective, the requirements for a public announcement are already fulfilled if a significant proportion of the potential, realistically reachable prospective buyers has been given the opportunity to learn about the upcoming auction. The systematic interpretation is based on the principle of coherence within the legal system, according to which legal norms are presumed internally consistent. Conclusions regarding the content, scope, and intensity of the publicity obligation can therefore be derived from a systematic analysis of relevant legal provisions. From a personnel perspective, it must be ensured that the largest possible number of thematically relevant potential bidders is informed of the upcoming auction at reasonable cost and within a reasonable period of time. The decisive factor is not an abstract maximization of reach, but rather the targeted addressing of those audiences that can realistically be considered purchasers in light of the type, scope, and economic structure of the pledged asset. These potential bidders must receive information about the auction date sufficiently in advance to enable them to form an informed view of the company's shares or other rights to be auctioned, conduct economic and legal due diligence, and arrange the funding required to submit a bid. It follows that the type, scope, and intensity of publication, in terms of personnel, timing, and quality, are largely determined by the assumed market value, the economic and legal complexity, and the marketability of the pledged asset. The legislative objective of informing the largest possible number of potential bidders through publication of the auction is widely recognized and is confirmed by teleological interpretation. The purpose of the statutory publicity obligation is to increase competitive intensity through the most comprehensive yet appropriate publication. Such competitive intensity is a precondition for achieving the best possible auction proceeds and for striking an appropriate balance between the interests of all parties involved, in particular the pledger and the pledgee. According to statutory requirements, the purpose of publicly announcing the auction is to produce the greatest possible concentration of demand on the auction date in the market specifically created by the auction. To this end, the optimal number of realistically reachable and objectively suitable potential bidders must be approached at reasonable cost. The legislator attaches central importance to this concentration of demand, as it constitutes the best possible prerequisite for achieving optimal auction proceeds. The correlation between concentration of demand and proceeds levels is also supported by economic literature. Systematically, it follows that a notarial auction must likewise be published in such a way that potential bidders, at reasonable cost, are afforded a genuine opportunity to become aware of the auction date. Since realization costs are generally borne by the debtor as the responsible party, they are subject to a reasonableness standard. Targeted or even comprehensive identification of all theoretically conceivable potential buyers worldwide would clearly be disproportionate, not least in light of economic proportionality considerations. The costs and benefits of the publication measures must be proportionate. Pursuant to Section 1237 BGB, the announcement of the auction must be made publicly, properly, and dutifully not only by the publicly appointed, sworn auctioneer, but also by the notary. The same principles that apply to the auction announcement by a publicly appointed and sworn auctioneer must be observed systematically with regard to time frame, scope, and selection of publication media. A differentiation of requirements based solely on the identity of the auctioneer cannot be inferred from the statute. The pledge auction under the German Civil Code constitutes the public sale of pledged assets and stands in deliberate and emphatic contrast to a private sale. As it were, in Section 1235 BGB, the legislator expressly chose public auction as the default method of realization because the pledgee has no factual or legal influence over the sale of the pledged asset. The public nature of the procedure is the central and indispensable safeguard in this context. The public nature of the auction is intended to eliminate intentional or structural harm arising from the influence of any single party. It ensures that price formation is not controlled or manipulated by one-sided interests, in particular where the asset is illiquid or non-marketable, such as unlisted company shares or other rights. The public auction creates a market in the first place. Absent the auction, there is typically no transparent, comparable, or functioning market mechanism for such assets. The concentration of demand in terms of time and place on the market created by the auction is intended to prevent the pledged asset, including company shares and rights, from being dissipated. The practical effect is that it becomes de facto impossible for the pledgee to depress the top bid in a targeted manner or to acquire the pledged asset himself at a price below the optimal achievable value. Such influence would operate directly to the detriment of the pledger. Moreover, if the auction proceeds are insufficient to fully satisfy the secured claim, the lying creditor typically remains entitled to pursue the debtor's remaining assets for the shortfall by way of further enforcement. In that scenario, manipulation of the auction outcome would confer a double economic benefit on the pledgee. In legal debate, it is often argued that public pledge auctions are structurally akin to distressed sales and therefore entail an increased risk of dissipation or sale at an undervalue. In current practice, however, this concern is materially mitigated by the expanded possibilities of online live auctions. Digital, location-independent bidding mechanisms allow a substantially larger, yet still suitable, bidder universe to be reached nationally and internationally. The resulting increase in demand intensity effectively counteracts the risk of undervaluation of the pledged asset. Public announcement, market approach, and liability consequences for auctions of company shares and rights. Traditional print media have lost significant reach and impact as a result of digitalization. Against this background, it will generally not satisfy today's factual and legal standards to limit the public announcement of an auction solely to a mandatory notice in the Federal Gazette or in a daily newspaper authorized for public notices. Such minimal publication frequently fails to generate meaningful market response and is therefore typically unsuitable to achieve the purpose of Section 1237 BGB. In practice, it can be observed that public auctions, in particular those conducted by notaries, are frequently announced only via these traditional channels, often limited to a formal short notice in the Federal Gazette. However, such an approach is insufficient, because it does not meet the mandatory requirements for a legally compliant public announcement derived from the grammatical, systematic, historical, and teleological interpretation of Section 1237 BGB. Instead, the identification and generation of suitable prospective buyers for company shares and other rights requires an approach aligned with current and a practice and established principles of banking, finance, and business administration. This includes market analysis, target investor identification, structured investor outreach, and the use of modern national and international communication channels. For notaries, conducting public auctions is typically an ancillary activity, and under the German Notarial Code, Notarordnung is only permitted in connection with a notarization. Public auctions of company shares are comparatively rare. Maintaining permanent staffing with specialized M&A, valuation, and capital markets expertise is generally not economically feasible for a notarial office. Against this background, it is typically neither feasible to deliver a public announcement meeting legal requirements nor to identify and approach a properly defined group of potential buyers using the staffing typically available in such offices. Delegating the public announcement to the pledgee or its representatives, such as lawyers, advisors, consultants, or other third parties, does not satisfy the requirements of Section 1237 BGB, since the creditor is always entitled to exercise his co-bidding right pursuant to Section 1239 BGB. Co-bidding by creditor and owner. It must be assumed that he and his vicarious agents are structurally conflicted. The pledgee could be accused of unilaterally shaping the process to the detriment of the pledger by selecting the selling party and designing the announcement. If an auction is announced arbitrarily or inadequately and the pledged asset is sold to a purchaser favored by the creditor or even to the creditor himself, the creditor may be accused of negligent or grossly negligent dissipation, sale at an undervalue. This applies in particular because, if the auction proceeds are insufficient, the secured creditor generally remains entitled to pursue the debtor's other assets for the residual claim. In subsequent insolvency proceedings, such underrealization is also detrimental to other creditors. In contentious proceedings, the pledger may be required to prove who actually made the public announcement, when, how, and through which media, as it were. If the requirements of Section 1237 BGB are not met in all material respects in notarial auctions, a legally compliant public announcement has not been effected. Public auctions of company shares or other rights are frequently disputed. If the sale is not carried out in compliance with statutory requirements, the party commissioning the auction, typically the pledgee, is initially liable. This is particularly important in the event of the pledger's insolvency. An insolvency administrator may challenge the legality of the auction and assert damages claims. Moreover, insolvency proceedings often involve legal aid entitlements, which significantly increases the pledgee's litigation risk. For these reasons, when instructing a notary, pledgees should, in their own liability interests, make full and verifiable compliance with the requirements of Section 1237 BGB in all the dimensions described herein and express precondition. Against this background, many notaries now decline to conduct public auctions of company shares or IP rights and refer the matter to suitable publicly appointed and sworn auctioneers. The auctioning of company shares forms part of the regular professional practice of a publicly appointed, sworn auctioneer specializing in this field. His commercial and economic training enables him to identify the relevant bidder universe and to ensure an appropriate, legally compliant public announcement. Like the notary, the auctioneer is sworn to independence and conscientious performance of his duties and carries out publication in the interests of both pledger and pledgee. The legislator has deliberately not enacted a dedicated set of implementing rules for public announcements by publicly appointed, sworn auctioneers. Instructions applicable to bailiffs do not apply to them. The auctioneer is typically remunerated on a success-based basis, as a percentage of auction proceeds. In his own economic interest, he therefore has a strong incentive to publicize as comprehensively, appropriately, and effectively as possible. Unlike bailiffs or notaries, he is not remunerated on a flat fee or fixed fee basis. The publicly appointed, sworn auctioneer determines, in the proper exercise of discretion, the type, scope, and medium of the announcement, taking into account the specifics of the individual case. This may include publications in print and online media, specialist internet platforms, social media, press relations, newsletters to known investors, targeted outreach to financial and strategic investors, market analyses, and national and international direct approaches to potential bidders. The aim of the public announcement is to inform those persons who could be serious purchasers in the specific case as comprehensively as possible about the upcoming auction. For high-value company shares, compliance with these principles regularly requires that the auction be publicized through all relevant national and international communication channels. Otherwise, there would be a risk that the pledgee could indirectly influence the scope of publication by selecting the auctioneer. According to historical interpretation, disclosure requirements were intended to inform the largest possible number of potential bidders. The original version of the BGB referred to a customary announcement. The legislator deliberately removed this term in order to reflect the conditions of a globalized economy and modern communication methods. The aim was and remains to ensure a public collection of bids free from creditor influence. Finally, teleological interpretation confirms that Section 1237 Sentence 1 BGB is intended to resolve a typical conflict of interest and prevent manipulation of price formation. The objective intent of the legislator is decisive. The Federal Constitutional Court states in this regard, the interpretation of a legal provision cannot always remain confined to the meaning attributed to it at the time of its enactment. It is necessary to consider the reasonable function it can perform at the time of its application. So, thank you very much for your attention. For more information or to contact us, please visit our website as shown below.